very many apologies for the delay because of a couple of technical issues which seem to have been resolved. Again, my name is Caroline Wallitt. I'm a litigation partner here at Kirschenbaum Kirschenbaum, and today I'm going to spend a few minutes discussing litigation defense with no insurance coverage. And I just wanted to, as a heads up, my specialty is litigation, but because my subspecialty is healthcare, and my focus in terms of my client work is on the healthcare industry, I do handle litigation type matters like audit defense, when, for example, an insurance carrier will come after a medical practice to recover money that they allege is overpaid, and I also handle OPMC proceedings. So we're going to be discussing a little bit of that today. So moving on to the second slide. You get a sense of what I do. I almost exclusively represent physicians in employment, practice sale, IP type work. Like I mentioned before, the audit. We handle some, in very limited cases, malpractice, mostly contractual and business tort disputes. I have a lot of experience with pre-litigation when I have clients who want to get a result but do not want to have to sue to get it. I find that it's often very helpful to engage in some sort of pre-litigation discussions, a little exchange of documents perhaps to avoid the litigation. But I do try cases, and I do handle litigations both in a court and in out-of-court proceedings like arbitration. Today what we're going to talk about is, as a precursor, an ounce of prevention. Nobody wants to be sued. Nobody wants to be audited. Nobody wants their license to be on the line as possibly being suspended or revoked or some sort of limitation put on it. So I wanted to just talk about ways that physicians and medical providers can mitigate the risk. You can't always prevent everyone from suing you or prevent any type of proceeding from being commenced against you, but you can implement practices that will make it less likely, and that if it does happen, may help you get out more quickly because you've got a very streamlined, tight defense. Then we're going to go over the golden rule when it comes to finding out if you have coverage, the reasons for non-coverage, and some best practices. And then some best practices if you do find that you are sued and that you have a defense that is covered by a carrier. And then we'll talk about who are the people that can help you in these issues, our areas of expertise, and some resources that we have. Ounce of prevention. Like I said, technically nothing prevents litigation, but some best practices may mitigate it. And it'll come through in the hypotheticals that I give at the end. When you have your own medical practice, you really just focus on patient care. And then you realize that there is business considerations. And so you take those on, and then you start to realize that there are also legal considerations. I hope to be able to give you a number of best practices that will help you avoid, mitigate, or get out of a litigation very quickly. First best practice, know the law. And I mentioned this loosely. There's no need for physicians to know the law because then there would be no need for attorneys. So what I'm saying when I say know the law, you should know that there is an area of the law that you need to know some very broad stroke basics. And you know that you need to be relying on some professionals to help you gain the knowledge that you need to keep current with that area. It could be your attorney. You could maybe hire a compliance person, or you could be self-taught, but usually physicians don't have the time for that because they're busy practicing medicine. But you need to know the broad strokes of certain areas of law and know that you need to have someone to rely upon to give you the details, to answer the questions. That's know the law. And some of these areas are employment law, billing practices, some of the corporate structure laws that New York has with regard to business entities that provide medical care. Second step, teach the law. Whatever you know, make sure that everybody at your practice knows to the extent that it relates to their position. If you have managerial staff or staff that are supervising, you want to make sure that they know about what you know, which is the broad strokes with regard to employment law. If you have billing people, you want to make sure that they know at least what you know and that they have resources to get more. Although feasibly, billing people should really be into the details. The way that you teach the law is, with in-services, lunchtime, meetings, to give people updates on what the law is in a certain area. And this will all probably come to light with the hypotheticals. You make the law easily accessible to all, meaning you have to have manuals, maybe a billing procedures manual, an employment manual. You're also going to need to implement the law consistently. Whatever has worked, you need to keep implementing it, because the only way that you can be sure that you will be protected is if you take a good practice and apply it evenly across everyone. So that means that when you have a certain disciplinary policy, you need to apply it consistently. If somebody is constantly late, the first step, would be a warning. The second step would be meeting. The third step would be probation, and so forth. Make sure that you implement it consistently among staff, and that your managers and your supervising employees implement it consistently among the people that they supervise. And then what's really the golden rule here, it's kind of a mini golden rule, prove it with a paper trail. When you implement the law consistently, you want to have some sort of proof. And paper trail is really the only way to do that, because otherwise you're forced to rely upon people's recollection of what happened. Yeah, I think we did the same thing. I think we applied this rule very consistently. And people's recollection isn't the most reliable. It lacks details, it lacks precision, it reflects bias. You want to have documents to be able to substantiate the fact that you implemented the law. And then finally, whenever possible, try to make your contracts include provisions that discourage litigation and encourage resolution. And here's an example, is that if you have a vendor contract, employment contract with someone, it's a good idea to have a provision that says if you have any issues with this, with compliance with this contract, what you need to do is, before you commence a litigation, there needs to be some sort of mandatory mediation. It's going to bring the issues to light and get rid of a lot of things that could become very big, expensive things. Let's go through the hypotheticals. How do you apply the best practices in employment law? So you're going to know the broad strokes. You're going to know certain things like, you can't fire people if they're in a protected class. And that usually means a racial minority or some sort of religion or gender minority. Also somebody who's got disabilities under the ADA. Or you also cannot fire somebody who complained about something in particular, like discrimination, harassment. Know the broad strokes. Be sure that you teach that to others. Be sure that others know what you know, and maybe even a little bit more. Make the law easily accessible to all. In the employment context, a handbook is a really great way to do that, because it's distributed to employees. Everyone should have a copy. Everyone's on the same page as to what the law is. And, employee handbooks are filled with, New York law requires us to do sexual harassment training. And so you will be required to complete certain sexual harassment training before, you start working for us, and so forth. And And so implementing the law consistently then becomes easy when you have a manual. For example, I had a client who was a medical provider. He had a number of nurses. One of the nurses was marginal in terms of quality of work, but she was less than stellar when it came to attendance and less than stellar when it came to punctuality and coming to work on time. So there came a time where she complained about sexual harassment. And so it was handled. I would say that, my client handled it perfectly. But then there came a time where afterwards, the nurse's performance got worse and worse and worse. And she started coming later and later and later. And this is where implement and prove it became very important. According to their handbook, if you're late all the time, there's a progression of conduct that the employer needs to implement to be able to put the employee on notice that, your attendance is subpar. Your job is on the line. And it starts with a verbal warning, then a written warning, then some sort of probation, then like a suspension, and then a termination. Right here, the employer did implement consistently the handbook and was able to prove it by showing records, because luckily this employee punched in and punched out, so they were able to tell through the records when this employee was late, and then they were able to pull up from the employment file the way that they disciplined her and how it was consistent with the employee manual. The doctor was able to show, listen, it happened, she got verbal warnings. Look, we put it in an email. And there's no need to have a full-fledged HR department here. There's no need to have memos. Sometimes it could just be an email. Sometimes it could just be something where you send an employee an email that says, like, I'm looking at the timesheets and you're always late. Let's come into my office. Let's talk about what's going on, see if there's anything that can be done. And you take that email and you have a meeting with the employee. You need to have another person in the meeting there to be able to be a witness besides you and the employee. And, have the employee sign that very email that you printed out and put it in the employee file. That way you know that you had a meeting about this and that you maybe went through the first or the second or however many steps you had in the progression of discipline. And luckily, this employer was able to show that he ultimately fired this nurse, not because she had complained about sexual harassment at some point. He was able to show that it was for other reasons. It was because the quality of her work was further declining and because she was absent and late quite a bit after she made her complaint, and she was put on notice of it. Second hypothetical is, in the event of an insurance audit where a carrier comes and tries to recover money that they previously paid to a medical practice, but then decided that it was not supported by documentation or it wasn't medically necessary. So you need to know the broad strokes. You're not a biller, but you need to know generally what kinds of procedures you're doing, what are the right codes, what are the right modifiers, and how the chart should look. When it gets down to the little details, you don't need to know all that, but you do need to have everyone else taught billing procedures. You need to, as it relates to their job, of course, you need to make it easily accessible to all. So instead of an employee manual, I would imagine that you would have a billing procedures manual that would probably be appropriate for billing staff. And you implement it consistently, that whenever there's a type of procedure, it's always done like this, and you prove it with the paper trail. You show that this is how we were taught to do it, this is what follows the law, and this is how it was done on the charts, so that when there is an insurance carrier audit, that ultimately will be proven that you complied because you have the law written, it's accessible to all, it was implemented, and you can prove it with a paper trail. So those are some ways to either prevent or mitigate or offset or get out of litigation early. But let's say that someone commences a litigation against you, or someone files a claim against you, or someone sends you a letter of complaint saying that you may have committed some malpractice, or that you may have wrongfully terminated them, or you get a letter from OPMC or an insurance carrier. Always, always, always ask your broker about coverage as soon as you receive notice. At this point, your carrier is going to consider you being on notice, and at that point, your broker should be engaging in a discussion with you about, okay, is there coverage under your policy? Should we be putting the carrier on notice? Or is this something that is so low stakes that it can be resolved, without having to file a claim? But that is something that is for a decision for you and your broker, but your broker needs to be looped in order to make that decision. So the golden rule: once there's a claim, a dispute, anything, just contact your insurance broker. Say, I don't know what this is, but it may be something. Sometimes you're covered, sometimes you're not. If you're not being covered by a carrier, then that means that the dispute or the proceeding usually concerns an area of law that's not typically covered by insurance. OPMC proceedings, audits by insurance carriers, partnership disputes, sales gone wrong, a lot of restrictive covenant issues are, often not, unfair competition issues are not covered. Although with each of these examples, I still want everybody to be contacting their brokers, because there are some policies that you're able to purchase that, do cover defense and the possible, fines, penalties, judgment in any of these areas. The only time that it's really not covered, I would imagine, is by a policy that you can't buy is one that concerns fraud or criminal behavior. So the examples I gave, not covered. The usual areas for coverage are employment law, covered by an EPLI policy, medical malpractice actions, typically covered, any sort of negligence, like an injury, like a premises liability, those are typically covered. So if you're not covered, you're probably in one of these areas that's a non-covered area. Another reason that you might not be covered is because your carrier disclaimed coverage. If you provided late notice or no notice, or did too much to try to handle the matter on your own, the carrier may say, you know what, it's too late for us to do anything here. You should have given us the opportunity to get involved earlier. We're not going to cover. Third example is a gap in coverage. And this happened with a particular client when an office manager left. They had a medical practice in one of the outer boroughs. When an office manager left, one of their policies lapsed. And it took a while for them to realize it. And then when they got a new office manager in, she was able to reinstate it. But it was a policy that had to do with premises liability. So unfortunately, they were sued by a patient who had gotten hurt at their practice, and they realized that happened precisely during the short period of time that there was a gap in coverage. And then the final reason for non-coverage is if you just elect to proceed without it. And this is what I was talking about earlier, vetting the decision with an attorney, a broker. An attorney is not going to be able to tell you if it's covered or not, but an attorney is maybe going to be able to tell you, oh, hey, somebody's really just disputing a certain bill. I don't know that you really need to file that claim with your insurance company because it can probably be resolved for way less than your deductible. So you've got a dispute or a proceeding. It's not covered. What's your next step? You choose your counsel wisely. You cannot represent yourself in the state of New York if you have a business entity that is involved, meaning a PLLC, a PC. If you are named personally, in some instances you may be able to represent yourself, though I don't recommend it. You're going to need an attorney, chances are. So look for a supervising attorney with relevant experience. And this is not the time to be talking to your uncle's neighbor who's like a patent attorney if it does not concern patents. You really want somebody who does this. I wouldn't say 100% of the time, but who has a level of experience and is dealing in ongoing cases in the area of law, whether it's med mal, whether it's employment, whether it's audit defense. You want someone that practices that type of law. And then when you select somebody, you don't want to finalize the relationship until you're candid about your ability to pay. Every client has a different level of money that they want to spend on litigation or dispute or defense. And be sure to disclose that, because that's something that you want out there from the beginning. You want to request a loose litigation budget from your attorneys that you're vetting. And I say loose because litigation is very unpredictable. You can never really give a number for it. This is only going to cost you X amount of dollars. So I would basically request that, look at it, and then figure out, can I pay this? Because if you cannot even pay the loose budget, then you need to have a follow-up talk and try to figure out what your other options are. Because typically the loose litigations budgets grow. You need to also see if alternative payment arrangements are available. Now, if you're the defense side, you're not going to likely be on a contingency payment arrangement because you're defending. Unless you have stellar counterclaims, you're just going to be put on an hourly arrangement with your attorney. But there could be some alternatives that you can explore, and I would say maybe try looking at caps in general, or a cap for certain types of work. Like you decide that maybe all the depositions are going to be a flat fee or a capped fee of a certain amount. That way that there's not going to be two depositions that are like $2,000 apiece and then like three that are $20,000 apiece. You could talk about what depositions are necessary, figure out maybe we should do a flat fee of like $5,000 for each. And then once you've explored that, you could reach some sort of agreement as to how many attorneys do you want working on your matter? How many are necessary? Do you want to look at your bill and see names that you don't recognize? How many paralegals are on there? It's going to be a decision that is mostly dictated by counsel, but you should be familiar with everyone that is working on your matter. You need to reach an agreement as to what this attorney requires as to money on file. Do they always require that a retainer be replenished? And how that attorney's firm handles late payments. Getting those issues resolved before they transpire in the litigation cuts down on a lot of stress, because once the litigation starts, you really want to be able to focus on the litigation, on your defense. You don't want to be, having little disputes with your attorney about like, well, who are these people that came in and started billing and doing research? I don't know them. Did they bill a lot because they needed to get up to speed? Who knows? Get that out of the way before it becomes an issue. So you've got a non-covered defense. You've got an attorney. What do you do next? You hit the ground running. Make sure that your adversary, meaning the plaintiff and their attorneys, know that there is no insurance coverage, that whatever is, if they get any sort of judgment or verdict, that it is coming out of your pocket, because that will often set the perspective. It doesn't mean that somebody is going to scale back on prosecuting a case, but it does mean that someone's going to know, okay, I had, for example, a client that just didn't have medical malpractice insurance and then was sued for medical malpractice. And we informed plaintiff's counsel pretty early that there's no coverage. So whatever hundreds of thousands you were thinking to get for pain and suffering, it's not happening. Like, if there's some sort of settlement, then, we're paying for a lot of the out-of-pocket medical expenses, and that's about it. We're not going to be able to get you the kind of money that, people brag about getting in court when there's especially an insurance carrier. The next step is you want to just go through your files, both electronic and hard copy, to locate and turn over all relevant documents and communications to your attorney. Do it at the beginning. Do it at the outset. You'll usually know what's relevant. For example, the example of the nurse that complained about the sexual harassment, her performance went down, and then she was fired. Like, if she comes back to you and she claims retaliation, you're going to know exactly what you need. You're going to need her attendance records, you're going to need her employment file, and you're going to need any type of communication with her about her. It includes text messages and emails. For your attorney, you want to prepare a written narrative or a timeline or a who's who, because otherwise you're just going to be getting a lot of calls throughout the litigation every time a new area comes up and the attorney is like, listen, I saw these documents, I don't know what this is all about, can you bring me up to speed on this? And that's time that the attorney is spending calling you and billing you. So you want to be able to give the attorney a capsule of everything that they should expect to anticipate factually from this litigation or dispute. And you need to communicate your settlement position to your attorney. If you're lucky enough that you have the funds and the stamina to defend and clear your name and get what you believe is a very fair and just result, tell that to your attorney. Say, I want to fight this. I want to win. I want to knock my adversary down. They'll know. But most medical professionals are not like that. Most medical professionals are, want to just resolve early because they know that the cost can skyrocket. So, let them know. Say, anything up until X amount of money, I would pay. I would 100% pay to just make this go away because I'm going to spend that in legal fees anyways. And so encourage your attorney to explore early settlement options. And there's more that you can explore than just two attorneys calling each other to talk about settlement. A lot of courts have a mediation program that you could do on the cheap. They have mediators there, and if you just submit, a one-page sheet kind of summarizing the issues, you can get the mediator to hear your case for, I think the first couple hours are free, and then after that you pay a reduced fee. Most mediators in the tri-state area range between $200 and $500, although I think I've even seen some that are much more expensive, but those are rare. If you do a court-affiliated mediation, they're usually paying nothing for the first 2 hours, and then after that you're paying at most, $250 for the hour. Or see if the judge oversees settlement conferences. That may be a really good way to hit the ground running. You're defending yourself, but you're also exploring settlement at the same time. So after you really get into the thick of things, into the point where you've exchanged all your pleadings. Pleadings are the complaint, the allegations. You get to answer them in an answer. If you have counterclaims, you assert them, and then the plaintiff gets to reply. You get to bring in other parties. Once that's done, you're in discovery, where you exchange documents about the dispute and you give testimony about the dispute. When you're in the thick of things, you want to arrange some cost-effective status updates. And what I mean is, you got to figure out how you work. Do you want to be updated every month? whether something's going on or not. You want to get updated as things happen. For example, oh, hello, I went to court today. What happened? You want to be updated by phone? Do you want to be updated by email? It's usually better to have some sort of regular check-in period because that's an opportunity for you to save up your questions, or an attorney to save up their questions for like the biweekly phone call. And then they can say, oh, hey, how is this looking? And then you get to update them on that and say, hey, I need a follow-up document. Otherwise, you're just doing a lot of calls on the fly, and that can get to be expensive. Next, you want to establish guidelines for review of work product. If you're involved in, some sort of proceeding, dispute, litigation, the attorney is going to be sending out some work product on your behalf. It could be an answer. It could be briefs. It could be list of witnesses. It could be even just letters setting forth a position. So you want to be able to tell your attorney what kinds of documents you want to be looking at. Your attorney will guide you here. Your attorney will say, hey, this is this type of dispute. You can expect that I'll be preparing X document, Y document, Z document. You could say, I want to look at all of them, or I want to look at just the ones I need to sign, or I want to look at some of them and not others, or why don't you ask me? And let them know like how long you need. So for example, if you have an answer due on July 1st, you clearly don't want it the day before to look at, review, offer your feedback. You could at that point tell your attorney, I need 3 days, 7 days to be able to look at work product, meaningfully evaluate it, and be able to give you some feedback as to inaccuracies I'd like you to do differently. When you're in the midst of a litigation or a proceeding, you want to continue to trust your attorney. So I counsel you to avoid Google searching, sexual harassment litigations, because at that point you're going to be inundated in your search with a lot of garbage, and it's going to be hard for you to be able to sift through it, and you're no doubt going to be seeing things that you haven't seen your attorney do. You may not know why. I would just, the same way that doctors always tell patients not to Google an ailment, I would advise clients not to Google their dispute, because you're going to get a lot of garbage, some of which is not even correct, most of it which may not even be in the state that you are in, and laws do change by state. You need to be able to trust your attorney. Once you've chosen your attorney, you need to go forward with the knowledge that you've made the best choice you can, and that your attorney is going to do right by you. Same thing with cocktail parties, second opinions. Everyone always meets a lawyer at a cocktail party, and the lawyer always says, your attorney's doing that? I think I would do that differently. Don't. They don't know your case. They don't know the facts. They haven't seen the documents. They shouldn't be telling you how to run your case. Your attorney should be telling you how to run your case. But review your monthly invoices. That's the best way for you to be able to tell what is your attorney doing, because plenty of attorneys do work that they don't bill for, like a short phone call here or there, or maybe they get an article on a particular topic and they read it to get up to date on the new development in the law. But look at the monthly invoices. That's how you figure out what they're doing. Look at them, make sure it makes sense to you. One red flag that has been all over legal blogs lately is if you see any billing entries for a court appearance to hand up papers, that should definitely be something that you speak to your attorney about, because there are still judges that require, if there is, for example, a motion being briefed, that the parties exchange briefs, but then on the final day of the exchange period, they bring it to the court and hand it up to the judge. There are still judges that use this antiquated practice, but not many. So most of the time, if someone's writing that they need to go to court to hand up papers, find out, is this really necessary? Does this judge require it? Can I send some sort of, can you send some sort of staff member or junior attorney to handle that? It doesn't really require substantive knowledge. And when you do review your monthly invoices, ask questions, but dispute the billing judiciously. It's phone calls, every month to say, you know what, like you spent a lot of time researching this month. I only want to pay for 3 hours instead of 5. That's just going to break down the relationship. So that, and I'm not even going to get into how to handle a trial when you're not covered, because that is a whole other webinar. When you do have a covered defense, I wanted to spend a little bit of time discussing how that works in the state of New York. New York has something called a tripartite relationship, where you have an attorney, your insurance carrier, and you. The tripartite refers to the fact that it's both the client and the insurance carrier that are clients of the attorney. So that means that you lose out on some of the autonomy that you have in a non-covered defense. In the non-covered defense, you are calling the shots, you are paying the bills, except for the legal issues, which the attorney should be dictating, because the attorney is the one with the degree and the license experience. So as a client in the tripartite relationship in New York, that's trifecta between the attorney, the carrier, and the client, it basically entitles you to, must be updated as to the status of the litigation constantly. That's required by the rules of ethics, and to settlement offers. But that gets a little bit dicey. And what do you lose out on when you have a carrier footing your bill for the litigation? You lose out on choosing your counsel, because these carriers have panels of attorneys that they tend to use. And they're, for the most part, extremely competent, and they specialize in that area of the law. Sometimes you get to choose counsel, and that only really happens if there's a conflict of interest between the counsel that they've chosen and the one that you want. But that is usually, if there's a conflict of interest, then your carrier will just choose another attorney or another firm on the panel. Sometimes you get your choice of counsel if it's provided for in your insurance policy. So be sure that you and your broker both check. You also lose out, in exchange for having a carrier pay your way, you lose out on some of the litigation strategy. It's because, your attorney is going to be reporting into you, is going to be reporting into the carrier. The carrier is going to constantly be asking, okay, what is the exposure here? What is the level of risk here? And is perhaps going to be encouraging a settlement, whereas you might think like, oh, I'd really want to fight this. I don't know why they would want to settle. I would really want to fight it. You don't get to be the only one making that decision once a carrier comes into the picture. And then what else do you lose out on? The nature of the representation is changed by a carrier's billing guidelines. An attorney is submitting its bills not to you, but to the carrier, and the carrier has plenty of rules as to how the bills should look. The carrier may be setting limits on the nature, the type, length, and frequency of communication. Same for court appearances. It may be limiting deposition preparation. And so in that, for example, they may say like, you can only spend a certain amount of hours preparing for a deposition and only a certain amount of hours at a deposition. And that's something that if, you're seeing that, it may concern you, and then talk to your attorney, and you can figure out if it's something that you really feel you need, one particular witness needs much more time on, then, talk to your carrier and say, I know you only allow a certain amount of hours for depositions, but this is a very special witness. This witness has a tremendous amount of knowledge. This witness is integral to the case. We're going to need you to expand the number. And sometimes it works. So there's a tension in New York State and many other states regarding the settlement decisions in this tripartite relationship. Essentially, a carrier strategy cannot interfere with the loyalty to you, but oftentimes there's a conflict. There's a situation where maybe you would want to defend, clear your name, show you're right. Often that happens in medical malpractice cases, and the carrier is like, well, you know what? This case is only worth such and such. I'd rather just settle it and make it go away because it's going to cost more to litigate it. That's a conflict. And so under the ethical rules, your attorney must honor your decisions about settlement. Add some tension to there, because usually you're in your policy, there's a provision by which you have relinquished the right to make decisions about settlement, and that authorizes your carrier to make those decisions for you. So check your policy, and then have your broker check your policy. You do have the power, in most instances, to reject your defense for, easily for conflict. But if you feel that there's a competence issue, an issue with you clicking and being able to work effectively together, you always have the ability to reject the defense, assume the risk and expense of your own defense. But I would say that it's a tough relationship when the carrier comes into the picture, and the only thing that really helps is, if you stay in the loop, stay apprised of the matter, because that's ethically something you're entitled to. And when you see issues come up, talk to your attorney, get the carrier involved, because a lot of these rules, carriers may, in special circumstances, bend or waive or get you involved so that you feel that you're getting the best representation that you can get. So who's your team? We are talking about your healthcare attorney, financial planner, insurance broker, and possibly an accountant. So basically, when you get notice of sort of proceeding, dispute, or you're served with, a complaint in a litigation, get your attorney on the line. And like I said earlier in the presentation with the golden rule, get your insurance broker on the line too. Figure out if there's coverage. As much as I said that there's a lot of tension in that tripartite relationship, there's a lot more tension when you're having to pay for an attorney out of pocket. So see if there's coverage. And then a healthcare accountant is also going to be able to help you kind of manage, if you do not have coverage, what your litigation budget will be, how to manage it, and how to handle, any financial issues that come up in connection with it. So all of these examples that I've been giving with regard to the types of disputes you may be faced with or the procedures you may be faced with are among Kirschenbaum and Kirschenbaum's areas of expertise. I do handle a whole gamut of healthcare disputes and litigation. I do it before litigation is filed. I do it after litigation is filed. I try cases. I do mediations. I do arbitrations. We do audit defense. We do healthcare compliance so that you know that you're complying with billing protocols before an audit comes around. We have a transactional department that handles practice contracts and transactional matters. Of course, that's Jennifer. We handle a number of OPMC for medical professionals, ranging from competence, negligence, fraud, and we also have a practice collections department. Any questions, contact our attorneys. You can contact me. My email and my phone number are at the bottom of every slide. You can also get onto Jennifer's listserv to get the free newsletter that comes every Tuesday and Thursday morning. And you can also hop onto the website, www.newyorkhealthcareattorneys.com, because we have articles, topics, webinars, forms for a lot of issues that come up for medical professionals when they're involved in the practice that you may find helpful. So any questions, I'll be accessible by email. I'll be taking calls. Otherwise, I hope that you never get faced with a dispute or with a litigation or with some of these proceedings or audits. But if you do, I hope I've given you some ideas of how to proceed. Take a deep breath. It's going to be fine. Thanks very much for your time.